Hey Soham, hey Sweta.
Hey, Steph. Hey, Soham.
Hey, hi everybody.
Hi.
Very, very nice seeing you all. Folks, it is 7 on the dot. Looks like people are still showing up. Mm, but it looks like there are enough, enough people. Let's get started.
Yeah, I know. We've got a good audience pretty quickly. So,
Mm, yep. Awesome. All right, folks. My name is Soham. I run Interview Kickstart with the help of Ryan and Steph and a whole bunch of other people. Um, we do interview preparation courses, as some of you might know. Thursday evening, we get together and talk about one or the other interesting topic. We have had a series of things, a series of topics in the last few weeks. They're all recorded and saved as well on YouTube if you ever want to take a look. um, and today we are talking about immigration laws. And with us, we have Sweta. Sweta is an immigration lawyer, but I would love for her to introduce herself. She's one of the highest rated immigration lawyers in the Bay Area. And Sweta, would you mind introducing?
yes, thank you, Soham, for this glorious one-liner. But I'm Shweta Khandelwal. As Soham said, I'm an immigration attorney. Been practicing for more than a decade. Came as an immigrant to the U.S. I have done the whole 9 yards. H4, H1, F1, OPT, green card pending. I actually even contested a trig determination, which is a terrorism related inadmissibility ground, which had caused my own green card to kind of get lost somewhere in the in the dark hole, and I had to rescue my own case, and I was my best advocate, and that kind of set a path or a tone for my career. Picked up immigration. I'm pretty involved, not just with the profession as an attorney, but as an advocate, which means advocating for reform, educating people of their options, their rights under the laws, and the benefits, and how you can basically navigate the system. Because unfortunately, the thing with immigration is, as it's one of the most complex statutes after along with the tax code, but people just think of it as a form filing exercise, which is unfortunately just not the case. And we have very limited options that the law provides for people to come, to work or get green cards or work permits. There isn't much that the law offers in terms of pathways. So for people like, say, entrepreneurs or companies or founders, we are always kind of navigating the path and trying to figure out what option best suits what facts and circumstances for each case. So yeah, I can go on and on, but it's not about how much I love what I do, but it's about seeing what the audience has, and kind of helping people take this journey along with me.
Wonderful, Shweta. Thank you. Thank you for that. Folks, just like Shweta, I am also an immigrant, or I was, I suppose, before I got my citizenship. I was also immigrant to the U.S. I'm very grateful to the country, despite despite the immigration process. I must say, um, the my own journey was fairly straightforward compared to some of the cases that I've heard. Certainly. Um, so the other thing about immigration, which I've realized is, like, I think which Shweta also alluded to, is that a lot of these cases are very specific, um, and a lot of these cases are very personal. So today, I would love to spend more time taking questions from you as well, so that other people can benefit from Shweta's guidance. So if you have questions, please do raise your hands. At In a few minutes, we will take you upstage, and then we can go from there. Um, but before that happens, let's talk a uh, few general things with. I'm just very curious. Um, the the and I suppose curious about possibly one of the most popular topics on H1B these days. What do you see coming in the H1B landscape? um, and 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 there are two types of people affected by this. Like, one is people who are already inside US and people who are outside US, right? And just the way the things are going, right, some of the H1B rules have changed recently. Important rules have changed recently in the last couple of years. And what do you see the impact of those rules, and what are some of the things that you see on the horizon potentially coming? Obviously, nobody knows what's exactly going to happen and when, but what does the climate smell like to you? So that you're on mute if you're speaking.
Yeah,
Oh,
sorry about that. So we
no
had
problem.
a lot of these pushbacks on wage rules and stuff, right? Like how much the minimum salary should be on H1 wage rules, and it came to such a crazy point at which I remember there was a short while last year when Department of Labor went ahead and just made these increase the minimum wage requirements, and it said, like, say the minimum starting salary for an engineer in San Francisco should be $230,000. And by that I mean starting salary is not stocks, is not bonus, is just the base pay. Now we all know that
Wow.
that is sort of ridiculous, right? That's not how the whole I mean, that's not what a realistic expectation of entry level salaries for software engineers. It's high, but because it's all incentivized with stocks and bonus and all that stuff. So and thankfully that there was a lot of pushback, and those rules would never came into place, and otherwise it would have been a pretty sad situation for the economy here. The
Mhm.
good thing is now the what all these wage rules, the final until November 14, 2022, at least there is um, these changes have been pushed back. So for now we have the Department of Labor has delayed this until 2022, and which is a great start, right? And it also gives people an opportunity to now advocate that it's, I mean, forget about high engineers and stuff. These are not the kind of salaries that people in research positions or scientists or teachers and all expect to kind of make. So that's one thing. I mean, we really want to see how this wage thing unfolds. Of course there are so many other issues about increasing the quota numbers, and all these are bits and pieces of bigger legislative proposals. How does, I mean, there are some legislation, how does immigration reform ultimately unfold will be something that will decide how these things will change, because to get bipartisan support for these seems to be really the challenge, right? So let's see. I mean, there is
Yeah.
some good stuff on reform that has picked up, but at this point I don't think there is anything on particular on H1s which is gaining too much steam or traction. But having the wage rule pushed out was definitely a very welcome change.
Yes, 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 absolutely it was. That would have been ridiculous otherwise. Um, Fascinating. The For people who are not in the United States and they are thinking of coming to United States, right, in some or the other way, there are many people who aspire to come to US. They are either early career, they are mid career, they are not in the US yet. Like, what are some ways they should be thinking about? Now I'll give you a recent anecdote. One of my nieces, she wants to come. She wants to go for higher studies. That's sort of her thing, and she happens to have a lot of options today. She's in India, and she happens to have a lot of options today. When I was thinking about higher studies, there are very few options. Canada and Australia, for example, were not really there. US and UK were largely two options that I had. But today there are several options for a college student who wants to come. And so that's one category of people. The other category of people is people who are working and they are wondering how can they get to the US. Um, a lot of Indian companies have markets in the US now, and that is sort of that is one thing that they are looking at. Like earlier, one way to come to the US was to sort of join one of these TCS and Infosys of the world, and hope that they would be deployed offshore. But uh, uh, but that has become a little bit less today as well. Anyway, but sort of for someone like for someone who's working, um, what should they be thinking about? What are some interesting interesting ways to consider?
That's a very interesting question, actually. So the first is in terms of, now I'm going to kind of mix my experience as an attorney along with my knowledge of the law, right? Because here both need to be, both are relevant to give you sort of optimal answers. So, see, one, in practical terms, it's if you're looking for a job with a US employer, have being in the US, definitely, I mean, yes, we are all in this hugely connected world, blah blah, but there is something about being here, live, being a part of the ecosystem here, interact. And we all know here jobs in the US are not just about your skills. They're about your networking, they're about people, they're about, this community that you develop, right? So one way of being, I mean, F1, like a pathway towards, enrolling yourself in a university and kind of taking it from there, has always been a great option. And fortunately, a lot of, I mean, pardon my French, but for lack of a better word, a lot of the shit stuff that Trump's administration really did, because to make F1s a lot more harder. I mean, I won't go into the specific legalities of it, but there were some really, really concerning amendments to the law which would have continued to make the life of F1 students here even more difficult. So a lot of that stuff has been done away with. Okay. So to that extent, I mean, yes, it's still a huge challenge. I would definitely let people, it's always good to hope for the best and be, look forward to it, but be prepared. It's no cakewalk, because even say on OPT, if one you come here to study, I don't know whether the audience here is aware, you do get a year period, 1 year time for you to engage in some post completion, like, practical training, working, a work permit to work with
Mhm.
companies. But that work permit only allows you a maximum of 90 days of unemployment. So if you do not find a job within 90 days, you're technically not in status. So these are some really, I mean, you need to be prepared. It helps to be informed of these. For people in India who are considering higher studies, I would strongly advise that you work with a good counselor there, see what your options are, how you can kind of navigate your path from your F1 to an H1 to whatever it is. One, a good, if I definitely think, if for no other reason, I mean, if you're considering higher studies as a PhD candidate or whatever, that makes your path towards a green card much faster. So don't do a PhD for that sake; it's too much of work. But that definitely is sort of one way of going forward with it. In terms of other options, one thing that I would like to say, and especially with the available opportunities that you have even in India nowadays, like, working with one of these, your fang companies, that way you call it, your Facebooks and Apples and all these companies which have offices. If you work with an overseas office in India for a couple of years or whatever, you do have a good, you have the L1 option, right? The way, instead of using the H1, you have the intra company transfer, where, say, a Google employee in India can be transferred to the US or anywhere, on the L1 visa. The pathway to, that there's no lottery there. The pathway, if at all, to a green card is much faster. Of course, I mean, not all these options will work for everybody. I mean, it's huge. It's all driven by the employer and what your employer wants to, where they want to send you and stuff. But if you are able to navigate your way through and leverage these to your advantage, then that could be a great option to move to the US as well. Considering working with any of these big companies there and then eventually transferring yourself here. And in terms of I mean, if you really have the investment and you want that option for your kids and stuff, just outright you can buy a green card. I mean, you need $1 million and you invest and you can get a green card for yourself and your family. And $1 million is really not too much in today's. I mean, if it's an investment, it comes back to you. You don't, you're making an investment. Let me add it. It's not buying and never. If you make a sound, I mean, this is I'm just the way I'm discussing these is just like at the tip of the iceberg. But if you make the right investment choices, that money does come back to you. So in return for that investment, you are able to sort of buy your way into the US with a green card. So I can't really say much about options in Canada and Australia and others, but unfortunately, US's immigration policy is only benefiting other countries, right? So
Yeah.
I mean, this is they don't realize it. Like Canada, how aggressively they are kind of getting targeting, and we do see this even here. I almost every people are keeping options open and applying for PR for Canada, and just kind of getting tired of this whole immigration sword on their heads. But then at the end of the day, this is still the land of the opportunity of opportunity, right? So it is still the place which kind of for the lack of a better cliche, the American dream, which people come for.
Yeah, land of opportunity and land of taxes, I think. But yes, you're right. You're right. Fascinating, folks. Again, just to refresh the room, my name is Soham. I run Interview Kickstart with Steph and Prasad and Matt and Ryan and a whole bunch of other people. We do interview prep programs on tech side. We gather every Thursday evening and talk about one or the other interesting topic. Today we are talking with Sweta. Sweta is an immigration attorney, and we are talking about general immigration landscape in the US, and we are also taking your questions. So if you have questions, please do raise your hand, and would love to bring you up stage and see if we can help you. Especially, obviously, Sweta can help you. Let's see one final question, Sweta, and then we'll start taking questions. The let's see, how do I phrase this? How do you see the immigration thing unfolding in the next few years? Like, should people in the US be worried that it is going to get more strict? Should people in the US be like, no, it's about the same, or it's going to get more liberal? How do you think about it?
Well, I'm an optimist, and also I would say that there are we have seen some positive shifts with the Biden's administration's policy. Okay, so I wouldn't let's for example, that you have I don't know if you were aware, you had this international parole, the entrepreneurs parole, right, which was like giving basically an option for entrepreneurs to get a permit to live here and start their business. The closest that we've ever had to a startup visa, right? So we it was introduced during Obama eras, then it kind of went away during the Trump administration, and now it's kind of come back. So I'm seeing that there is some positive movement. There have been some other big ticket legislative items on immigration. The Farm Workers Modernization Act and stuff, which doesn't directly relate to what we are discussing here. So I am hopeful. I do think, but also, I mean, reform. This is something that this country has been struggling for more than 2 decades, right? So, and we've never ever come for a bipartisan agreement amongst the parties. So I mean, whether to specifically address what the maybe, whether will there what are the chances that the time that it takes for a green card to come, from 18 years or 15 years to come down to 2 or 4? I don't really have an answer to that question, honestly. But in
Yeah.
general, I do see things moving, and then there are some attorneys who think, oh, he's not moving fast enough. When I mean, President Biden is not moving fast enough on this and stuff. But I mean, immigration is not his only agenda. There are so just because it's not fast enough for us, I don't want to dismiss it. But I'm generally hopeful. I think there are some good things that are opening, and it will. Whether it'll totally be heavily in favor of people from India or China or not, maybe we don't know. But
Yeah.
it's definitely going to. It's not going to likely to get worse for the next 3 or 4 years for sure.
Fascinating. Um, the and with that, I'll also plug in that, folks. Kickstart. We are also hiring instructors. We're hiring instructors part time in all sorts of different kinds of subdomains of tech, embedded systems, data engineering, machine learning, you name it. And we would love to have you. um, Obviously, sometimes immigration gets in the way, and we have people who can help us go through that as well. So with that, let's see, Gagandeep, do you have a question we can help with?
Yes. Hi, Soham and Sweta. Thank you for doing this session, first of all. Um, I had a question like super specific to my situation. I'm on a cap subject H1B, and I'm trying to go. Actually, I'm on a cap exempt H1B, but I'm trying to go to a cap subject H1B. So the last 2 years, I've been trying to sort of do this, an interview with companies. This last year, I studied with Interview Kickstart and cleared most of the initial rounds. But when it came to the final rounds, it was super close to the visa deadline. So most of the companies, they backed out because they said that they could not sponsor. So could you please, would you be able to like briefly talk about like what are the options that I could sort of avail to go from a cap exempt H1B to a cap subject H1B?
I mean, if you're cap exempt, you mean that you're right now, so you're working with a non-profit or some entity or a
Yes.
educational institution right
Yeah,
now, right?
right now. Yeah, I'm working with a university right now.
Okay. I mean, one way to do this is, I don't know what your particular individual, I don't think this is the right forum to discuss your background and stuff, but I can generally just say, like, let's say, as I said, people with PhDs and stuff, or if you may be eligible for an O1 visa.
Mhm.
You can see the O1 is not subject to the cap. If you meet, you can just simply Google the criterion as well. It's not as hard as what USCIS makes it out to be.
Mhm.
And that is not subject to the cap. So if you qualify for the O1, that could be a great start. And I'm guessing the question of, if you did manage to crack the interviews with one of the top 5 companies, and they were paying you, they pay higher salaries compared to others, right? So it's possible that we could use that even as a criterion to move forward. But that, honestly, if you want to do it, maybe the company also has to be open for that. The other thing is, with many of these big companies, they're very rigid in what visas they will apply for people. So they'll only do O1s for people who have PhDs, which does not mean that only people with PhDs will get O1s, but that's kind of how they compartmentalize your cases. So you could consider that. I mean, again, I don't know whether on what path are you towards a green card. If there is any possibility of you getting an EB1 from your employer, then that is a great option that you can use and expedite your green card process. But otherwise, you just have to keep trying the lottery. I mean, that's like unfortunate. That's the only way, right? That's what makes the H1 such a deal breaker at times?
Yeah, the timeline for the lottery is a little bit challenging for me, specifically, because no company would hire me like an year in advance. So if I interview, say, right now, and apply for the lottery next year, and then I get my visa around like May timeframe. Well, I get approved for the visa around May timeframe next year. So I'll be able to join the company somewhere around September, October next year. So it's a little bit tricky with the timeline. I guess. I hope,
That is the whole H1 problem, right?
yeah,
That it is, but some of these companies, they are familiar. Most of them, they are aware of the timelines. I mean, they don't need to be. That's how they people on F1s and stuff, they know that this is the timeline that they have to do. The only thing is that if you already have an F1 or an OPT, I mean, if you're on OPT, you are currently already working there. So it maybe that process is a little more seamless. But I would say for you, it's a bit of a tricky situation because it's not that you can apply for this H1. The company ultimately has to apply for it for you. And they will
yeah,
only do it if the offer is clear and done, right? Like if they
right.
want you to hire you, then they do it, and which is subject to it. So there is a big. I would suggest you should try for the O1. I mean, if you want, you can reach out to our office. We can
Okay,
help you evaluate whether the O1 is a good option for you,
okay,
or you can have your university do an EB1 green card. Again, I don't know what your education background is, whether you would qualify or not, but that seems to be like the only way at this point.
okay, okay.
That's
Great.
interesting.
That makes sense. Thank you so much.
You're welcome.
Thank you, Gandeep. Thank you, Sweta. Just a curious question. So, O1s, can it be self-sponsored, or does the company have to sponsor O1?
O1 is self petition. You can't. So you can self petition. You cannot
Mm-hmm.
self sponsor. So, for instance, you can have your own company do the O1 for you. You can have there's a concept of an agent who can do the O1 for you, and then there is an agency agreement between the agent and the company where you will work, which these big companies are not very flexible with these arrangements. But if the point is, if he qualifies for an O1, or if anybody qualifies for an O1, then there is no lottery, right? I mean, then you apply and you can get it, and you can start any time of the year. You don't have to wait for this April and October and lottery and registration and all this bullshit.
Interesting. So, so Gagandeep could apply. They could self-petition with the help of an agent, and then the company would consider an O1 as a valid form of employment.
I mean, it is theoretically possible. You could do it, but I wouldn't say that is if he's applying really for these for one of your Google, the way he said he was working with you guys, Interview Kickstart.
Yeah.
And I'm guessing this is not like a small startup, right? This is one of the bigger league companies. They will not do these agency stuff. For them, they will directly petition for the O1. Okay, they will not work with an agent or whatever. See, an O1 can be just like an H1, and O1 can be petitioned by the company. The O1 can also be self-petitioned if need be. But in his case, the way he can't just say that I'm self-petitioning myself and I've got my O1, and now any company, I can work at any company. That's not how it will work.
My understanding of O1 actually was that O1 is for people with extraordinary capabilities. So, like anybody who's equivalent to like Priyanka Chopra in the tech world.
No.
Would get,
That's what I say. That don't look at. I mean, that was a colorful example, but don't look at it from the way the USCIS website will describe. Okay, because it will say, oh, either you have a Nobel Prize or you do one of. So everybody equates the criteria to a Nobel Prize. Okay, that's not how it is. So O1, let's say if you have publications, if you have original scientific contributions that you've made. If you are paid a salary which is much higher compared to other professionals in your field, if you are, let's say, for PhD people, they can review journals. Okay, they are always asked by these publications to review journals for them. If you are a member of a very, like, for a premium member of an IEEE or something like that. So there are ways that you can ramp up your profile to get an O1. But again, it's very hard to do that without actually knowing what your background is. But don't say, yes, you do have to show extraordinary ability. It is a high bar. I'm not discounting it, but I'm saying that it's not as high as they make it out to be.
Okay. Okay. That makes sense. But I guess I'll have to ask more offline. Uh,
Yeah.
yeah.
That'd be good. I appreciate that. Appreciate the
Yeah.
question. Thank you, Shweta, for the answers as well.
Thank you, Sweta.
The one little thing from my side, Gagan, is certainly not a situation to envy. Um, just that we've seen that Microsoft is slightly more open to visa shenanigans than other companies. So I'm
Mhm.
not sure where you had offers, but that's one tip
Sure.
there. The other thing is that these companies are obviously now getting more open to more remote and hybrid type work.
Yeah.
So and again, this is certainly a long shot, but you could ask them if you can work in a foreign office for some time and then come back again. Even if you have to try from scratch again, I think that's still pretty good, because even the foreign offices of these companies, they they have very good work and very good offers and stuff like that. So
Yep. Yep.
obviously it's a long shot. Obviously you should sort
No,
of exhaust the
actually,
options that you have.
so it's not such a long shot, because think of
Hmm.
it like, two people, employees here on F1s and OPTs and stuff, right? You have 12 months OPT, plus you have then 18 months STEM and all of it. So you have people working on OPT, and it is very common for them to have scenarios where people's H1s are not picked in the lottery and their OPTs are expiring, right? I mean, think of business graduates. They don't even have the STEM option, the extra 18 months. They only have 12 months. So the way they do this is they just simply move the employee to any other overseas office. And that's great. I mean, I would love to kind of take the opportunity and work in Geneva or work in Amsterdam or work in London. Like, why not?
Yep, yep, that makes sense. Yeah, that's a good option. Google actually was open to that option, so I'll see what happens with that.
Right.
Yeah, but Microsoft is a good tip.
Hmm.
Thanks, Soham.
Of course. Awesome. Thank you. Nishant, you had a question?
Yep. So actually, that is specific to green card GC. So, like, specific to EB3Q, what I want to know is that, like, I heard three things, and I want to know, like, how true they are, and like any timelines you
Hmm.
are aware of and how they impact the queue. So it is specific to Indians. So first thing which I heard is that like because of all this COVID thing, a lot of people have not, because there was H1 ban, like stopped for a very long time, and people from lot other countries like were not able to come to US, because of which lot of green cards have not even been filed, and like Indian queue might move faster because of that. Because since there were no applications at all, because people from small countries like let's say like Iran or Iraq or like any other countries, Brazil, Mexico, they have not come. That was the first thing. Second thing, about the country cap. So I heard like that bill like being passed like at Senate, and but I do not know like what's the timeline they are tracking where they are like increasing the country cap. Right now it is 7%. So how is that going to come into place, and like how the timelines will be affected? When can we see like queue moving? And the third one was like again the law which like Biden is like, I keep hearing in the news like increment in I guess 75,000 or something, some increment in the GC quota. So yeah, can you put some
Yeah.
light on these three?
These are, so regarding your first issue of the visa bulletin, I think uh, we see, when I say we, I mean immigration attorneys. If we don't do this analyzing of the visa bulletin, that is not our job. We stop doing it. We go by what Department of State gives us as visa numbers, And the reason is because there is no transparent data available to analyze this. Okay, I know it's really, we keep it's almost like a little joke amongst all the lawyers that this is what the clients do, like, analyzing and plotting and doing all of it, but we can't take that at face value. So to answer your question, I really don't know how the numbers will move forward. We don't, we only know the law, and we know that, we know what, how does it apply and what it can. There is no law that determines how these numbers will come out, right? So, and it's all conjecture, it's all based on, stuff like you say. Like, to give you an example, last year when the quota came, we never anticipated there'll be a second round of lottery, right? There is nothing out there which says that there will be, but there was a second round of lottery. So now if you ask us, will there be one this time, the simple answer is we don't know, because there is nothing out there in any of the regulations or whatever which says that there will be a second round of lottery. So I really can't comment onto this. I mean, I know, you can the Department of State official, I mean, I'm sure you're aware of Charlie Oppenheim. He comes up with these predictions. You can go and follow him and see what you think is scale is. But generally, numbers do advance in July, or they definitely move in October, right? Because that's the year when new numbers come into play. Again, talking to your question about legislation, I mean, this thing about per cap country bills quotas being eliminated, it's not new conversation. It's not like, but this is all a part of the whole immigration reform thing, and it by itself, you can follow the website in terms of the department. I don't think the bill has been ratified by the Senate, but it doesn't seem to be coming anytime very soon. So we are not talking about it. We are not, when I say we, I mean the lawyers. Nobody is preparing for it. Nobody thinks it's going to happen anytime soon, that we need to deal for it. So that's sort of the way I would answer. And what was your third question?
I guess there is a like increment in the total number of green card sets. I guess like I
Yeah,
keep
that's
hearing
same. I
them.
mean, all these are a part of,
Yeah.
it's a part of one. It is a bill which has tied to other things. Again, I don't think they are anywhere close to happening anytime soon. Because if it was, there would have been a lot more conversation about it amongst the lawyer community, and we definitely are not preparing for it anytime soon.
Okay, that helps. And like, what are the two things you told me? Like one person whom I can follow, and then there is a one side where I can check the status. Can we
So
repeat?
you have there is the person called Charlie Oppenheim. He is a guy who he's the one who's actually responsible for releasing the visa bulletin every month. Okay, uh, he's been working with Department of State for almost 30 years now, and the way we say it, he's the only one who knows how the bulletin will move. So most people get that if you have to get some insights, any from him would be the closest that I would suggest that you go to.
So it's like the
It's Charlie, CHARLIE Oppenheim, OPPENHEIM.
got it. Yeah, that helps. And is there a like I'm not very much following the bulletin. So is there a place where I can check the queue? Is there some kind of a bulletin or something where I can check what is the like current things and like anything like that? Like you
I
said,
mean,
like July and October it
you
keeps
mean
moving.
the visa bulletin?
Yeah.
Oh yeah, the visa bulletin comes out every month. That's the Department of State. So just type Department of State visa bulletin, and you will get a historical, current, future. I'm not future, current, past, all historical record of the visa bulletin.
Got it. Yeah. That helps. Yeah. Thank you so much.
You're welcome.
All right. Thank you, Nishant. Appreciate it. Thanks for that. This is interesting. Vasant, did you have a question?
Yeah, yeah. Thank you. Thanks, Soham, and thanks, Shweta. This is like a very insightful room. So I had a specific question related to my situation. Like I had filed for my AOS back in October using the filing date, and it was done like under the EB2 category. I do see that like the dates have moved drastically right now for EB3, and the EB3 dates are like even current. So one question I had is like about this whole concept of interfiling, because there is not much of literature around like how that works. I was advised that I could actually file another EB3 petition right now and then try to interfile my existing AOS with the new iPhone 40 once it's approved. I'm not sure like what's a good course of action to take. So can you educate us on what this interfiling is about?
When you say interfiling, you mean downgrading from EB2 to EB3?
Right. So I was told that like I can have a parallel I-140 filed for EB3 because my I-140 for EB2 is already approved, and I already have the AOS filed with that EB2 I-140. So I was told right now that since EB3 is already current for the final action date, I can go ahead and file another I-140 for EB3 and then interfile this EB3
Okay.
I-140 to the AOS application.
But your but your AOS application is tied to an EB2.
It's tied right now to EB2 because it was filed based on the filing date, and back in October the filing date for EB2 was already current, so I never downgraded it then. But now the final action dates have moved so much that it's caused the EB3's final action date to be current for me.
Yeah. So I mean, uh, you can so you will have to sort of downgrade the EB2. What I'm trying to understand is you never did any downgrade in October at that
Yeah,
time. That
exactly.
time you did, right?
I did
Yeah.
not do it then. Yeah.
Okay. So you could potentially, so here, yes, you could definitely kind of do this. I don't like to use the word downgrade, but that seems to be popular. But you could do that for the EB3. So which means that you are sort of amending, you're filing a new, you're not amending, but filing a new I-140 under EB3. Now, the question of sort of tracking your old AOS to this current one, like basically saying, see, an AOS application is an AOS application. It's sort of the same one, right? Now, getting USCIS to point, like saying that, okay, instead of using that I-140, use this one and move my let my AOS be pointed towards this I-140. This is actually what we are doing right now. It ideally you shouldn't have had to file another AOS. You can simply, when you file the I-140 in EB3, you can tell them to consider this one and not that one. You know what I mean? But in practice it could be a little, I mean, I'm not a big fan of USCIS efficiencies, right? None of us are. So how quickly would they address it is one thing, and the other way is you can always refile another AOS if they don't do this job of connecting the old to the new and blah blah. So you can always file another AOS and say, well, consider this one. That there's nothing that stops them, you from doing it. It's waste of, I mean, it's extra money and time. But that is if they don't do their job of you know mm, point of moving of basically using the previously filed OS with the current I-140, you can simply file another one. I would say that you can also check with your employer's attorney and see what suggestion they have. Are they willing to kind of push for it, or are they willing to do the follow up? Because in these things, I mean, honestly, if I was a law firm, I would be like, it's so much simpler for me to file a new AOS and be done with it rather than keep tracking, going behind USCIS and do this. I mean, I'm more confident about doing something on my own than requesting them to do something, right? Because it's so check with them and see whether that's a possibility. And if they can do it. But if they seem hesitant about doing the AOS piece, ask them if we can do another AOS instead. So that might just make it faster.
Okay. Thank you, Sweta. This is very useful. Thank you so much.
Awesome. Very good. Thanks, Vasant. Thanks, Sweta. Vikas, do you want to go?
Yes, sir. First of all, thank you, Soham and Steph, for setting up this session. It's really very helpful. Like, I really look forward for Thursdays. Shweta, thanks for being here. My question is, I had filed my 485 kind of 6 to 8 months back, same during the October surge. I had filed my EB3 downgrade as well at the same time. I have not received my EAD or AP yet. My question is about switching a job at this time. Kind of what I normally have seen is it's recommended not to switch. But let's say if things are not going well with your company and you have to make a switch, uh, I have a couple of questions. What is the process of moving this 485 application to the new employer? And second is, what are the issues that you have seen in your during your practice that people face while making this 485 switch, and whether it's a recommended option to do? So let me know if
So
I
you,
can.
when you say you're switching, do you mean you're switching after the adjustment is filed, and
Yes.
you're not you're switching under the AC21 portability?
Yeah. So if 6 months have been done, then if
Right.
my
So
my
you are
485 has
switching
been.
under the AC. Yes, you're switching under the AC21 port. That is a statute that allows you to port your job 6 months after the adjustment is filed. Okay. So
Mhm.
your initial, was that an EB, whatever it was, EB2 or EB3? You filed the adjustment. It's been, so one thing. Remember, you will will need the EAD to move, right? So you not only have to wait 6 months from the adjustment being filed, you also have to wait for the EAD. Your I-140 is approved.
My EB2 was approved, but my AOS was filed as per my EB3, right? So EB3 is not approved.
So I would first say that if your AOS was filed for any portability, you can move 6 months after the adjustment is filed, okay? But your employer may then withdraw this I-140.
Got it.
Because you do need an approved I-140 ultimately for the portability to take effect. So let's say if you move now with the I-140 pending after 6 months, after getting an EAD, if ultimately the I-140 is approved, great. But if ultimately the I-140 is denied, or if the employer withdraws the I-140, then there is no portability. You can't have portability until the underlying I-140 is approved.
Got it. And in that case, you have to redo right from the scratch, like labor 140.
Oh,
and all
yeah.
those things.
Then you do keep the priority date, but you have to redo everything from scratch.
Got it. So you're saying after EAD, it's a kind of, if your 140 is approved and you receive an EAD, that would be a safer bet to take than
You
doing it.
have to have the EAD. Not having the EAD is not an option, because how will you work? You need a work authorization, right? So
I can still, like,
and
my H1B is still valid, right? So I can
yeah, but
transfer.
then are you going to transfer your H1? You can do that as well. You can transfer your H1 and start working, but to keep the benefit of portability means what? That you don't want the new employer to do the perm and the I-140 again, right?
Correct.
That is what you want.
Yeah, that is
So
what
if
my
you want
intent.
that, yeah, so if you want that benefit, you have to wait 6 months after the AOS is filed. I guess you don't need the EAD because you are working on H1, but you ultimately do need the I-140 approved.
Got it. Okay. And kind of, is that recommended? Because lot of times I have heard people saying, oh, even after EAD, you should be waiting for 6 months because you may be asked some kind of hard
No.
questions during your interviews. So
No. I mean, well, that's the whole idea. The 6 month period is there. 6 months from adjustment being filed, you can port. Yeah, of
Got
course,
it.
you port to a similar position or similar thing,
Exactly.
right? You don't port to start your own rock band or whatever. That you don't do. But
Got it.
you definitely can. Yeah.
So what I understood
Well,
is you haven't seen any major issues while, let's say, if people have EAD and people's 140 is approved and people are moving on this AC21, then you really don't see major issues getting green card for that person. Is that right?
No. And again,
Got it.
remember that unless you are unemployed at the time your adjustment time is there. I mean, bottom line is you have to have a permanent job offer closer to your final action date. You
Got
can't
it.
be unemployed, right? That, because it's an employment based application. So if closer to your final action date, closer at the time of the interview, you have to be working in your field of in your field. Yeah. So then it shouldn't be a problem.
Thank you so much, Sweta. This really helps answer my question. Yeah. Thank you.
So Vikas, don't start a rock band unless you're a rock star. You see. But another quick question. So, what are the chances of company revoking I-140 or getting denied?
I mean, denial for any number of reasons, Soham. Okay, denial could be, I mean, just because it got approved once. Also, like all these downgrades and stuff that people are doing, you never know. Denial, they could. I can't say it shouldn't, but I don't know. Maybe they filed it by they made a mistake. Maybe the company can no longer show ability to pay. All that stuff is there. The thing is, once an I-140, like they can revoke it, but I mean, ultimately, the company which is where I'm trying to understand the context of the question. The revoking of the I-140 doesn't have. You can always keep the priority date even if the I-140 is revoked.
Yes,
that is not a problem.
I think the context was he was switching on AC21, and the guidance was that make sure I-140 is approved. So that's what I was wondering. Like, what are the chances of company revoking it or it getting denied?
No, the company can revoke it after 6 months. That will not change the portability. But if the company, in his case, if he says the I-140 is currently pending. So if the company if it is pending, then what happens? Let's say if there's an RFE on the I-140, the company is not bound to respond to the RFE because the employee is no longer with them, right? So that kind of an understanding that, okay, let's say even if the company, if you are on good terms with the employer and you tell him that don't what I'm trying to say is that there is no portability with a denied I-140. Okay, ultimately if the I-140 gets denied, there will be no portability. The company can many times if the employer withdraws and it transfers and the I-140 is still pending, then the company is under no obligation to say respond to an RFE or something, unless you kind of agree to them that, you know what, if you part in good terms, that like just ensure that you don't revoke the I-140. That's a possibility.
Makes sense. I just recall I actually switched on portability to box from eBay. Obviously, early days of eBay. My I-140 was not approved at the time. I think I just took the chance and switched because I just wanted to, and then it got approved. But obviously, I was not a downgrade, so it was just a more or less a very smooth process. I had also had no other sort of issues in the immigration until then as well. So I don't know who this helps, but that was my experience. I mean, for me, many years ago, the portability was very smooth. So, okay.
Yeah, I think the key is also many years ago. Because
yes.
Of course. Actually, it's kind of so funny that you said. I recently, one of my colleagues said that she had a client who originally got asylum, and the reason, what is an asylum? Asylum is when you tell an officer that you fear for your life in your home country, right? So every time someone shows up before if they don't let you enter, they have to ask you that, are you scared to go back to your home country? And if the person says yes, then you're sort of, at least you can apply for asylum. So this woman said, I don't want to go back to my home country because I'm scared of my mother-in-law. And she was actually given asylum. Okay.
Oh God.
This happened like maybe 40 years ago or 45 years ago. But that was the state of immigration laws at that time. And you compare it to what we are seeing today. So, I mean, of course, yours was not that old a case and not as ridiculous an example. But it is a true story.
Fascinating. All right, we'll do a session on that someday. Very good, reminiscing on the old times in immigration. Okay, very good. Let's see, folks. I have to leave in about 5 minutes, but we will continue the conversation with Steph, Prasid, and Sweta here. Let's see, Naveen, do you have a question?
Yes. Hi, Soham. Hi, Sweta.
So I wanted to ask you about a scenario like my priority date right now is May 2018, and I have an approved I-140 in EB3 category. So many people are trying to change jobs, but given that many lawyers and everyone in online is saying that this year maybe I-140, I-485 can become current for people up to 2020. So it's not good to change jobs. Wait for I-485 to submit application, and you can get in the queue. So what do you suggest? Should people go for changing jobs at this moment, or wait uh, to get in a queue in this October?
See, look, again, anything that goes to do with the predictability of the visa bulletin, I it's hard to kind of say. I don't even want to advise, because that's 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 not something that I want on my conscience at all. But I mean, the point here being is, it's you can, I don't know how quickly can your new employer file a permanent I-140 to recapture the old date thing. It's I really cannot advise you based on what is the likelihood of the visa bulletin going the way it is. That just too um beyond my wheelhouse, really.
Right. Yeah. So
Because
actually, I spoke to them, to the new employer, and they said they will file green card and they will do the perm application from when I join. But you also know that the stage one also takes a lot of time, at least a year for
it does,
prevailing wage.
exactly. So that's the time. I mean, your risk here is, I mean, going by assuming that whatever your predictions are or whatever you are saying happens, and I'm not kind of going there to it at all. What are the chances? I can tell you what the risk is if it happens. Okay, I'm not
Yeah.
going to comment on whether or not it's likely to happen. I would say that because the perm by itself is going to take you about, I mean, to get a perm certified from now, it's at least 9 to 12 months.
Yes.
Okay.
And
Uh,
after that it is 140. So, and
yeah.
if we do it premium, it will at least take 1.5 months because of preparing the
Ye-
case and everything.
yes. 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 So the risk is that in this time, your bulletin may become current, and then again
Mhm.
it may go back several
Yeah.
years.
Yes.
That if at all that this is a possibility, right? So
Right.
again, I can't give you any ideas on how, whether what you should do, but this is kind of the possibility of what will happen if this thing gets current. Then in that whole window, if you might lose.
Mhm. So, okay, no problem. About 485, I read that it takes 8 to 14 months to approve, to get this approved 485. So, is this timeline from the date of filing or from the date it becomes current?
From the date the final action date becomes current, assuming it continues to remain current.
Right. Okay. Okay. Makes sense. So, if let's say if I change my job and right now, and because right now I have an offer and I change my job with approved I-140 and it is in EB3, but my new employer does it in EB2. So will it still be valid? My old I-140, old priority date will still be valid for the new 485?
Yes, they can keep whether your old priority date can be retained, an EB3 date can be retained for an EB2, EB2 can be retained for an EB3. That's not a problem.
Okay. Okay. Got it. I didn't understand one part when you were speaking about the AC21. So I was thinking that after 180 days, 485 has passed. Means, let's say I have filed my 485 and it's been 180 days. I read that it is risky to switch jobs because now the USCIS assumes that you are not currently employed at the same with the same employer and you don't want to stay with the same employer. So it is risky for them to approve it. So what is
That's not true.
AC21?
No, absolutely not. I mean, that is not true at all. There is a reason that the statute has given that provision, right? Why
Uh-huh.
have they asked? There is a reason the law allows you to do it. That after you have that, the question here is how bona fide your I-140 is. And in this case, I mean, people have it's been pending for years, and Your green card process is in queue for decades.
With what,
Right?
Nana? What is
So in that sense that there is no risk. I don't want to use the word it's risky to they will not think of some. No, that is not how the law is designed to work. The bottom line is the I-140 that is filed is a bona fide I-140, right? There is a specific provision in the law that says 180 days after filing the adjustment, you can move to a similar position, similar job classification. There is no risk associated with that.
We have to prove it, right? It is a similar job position, but
No, you don't
what
have to
kind of
prove it.
jobs?
I mean, uh, when you say you have to prove it, I mean, yes, you have to prove it, but you have to move to a thing. What is the fear there? What is the risk there? Generally the way we do it is we prepare an AC-21 letter, explain that this was the SOC code or occupational classification. It continues to be the same one now. And
Okay.
the statute allows you to do this portability. I mean, I think of it, okay? People are taking 18 years to get a green card. Is it realistic to expect that in all these 18 years, there has been no change in your job duties? It cannot be, right?
Right.
The law was never designed to for this kind of a practical scenario that we have. This is what we need reform for, right? It is uh, to answer your question, no, I don't know what this risk is that people are talking about, and that's why it's hard to comment on these based on the forums. But if you have a concern, you can get your situation reviewed and say, well, this is my thing, these are my job duties, do you see a problem? Well, that's possible, but in general I don't see any particular risk.
So SOC code does not have to be same, right, in two jobs, or
It's
they have
mainly
to
your
be.
job duties.
Right. Okay.
It's mainly what your job duties are. I mean, the general is you can't have a major switch. You can't move from development to management totally, or to finance or whatever. But as long as the majority of your duties remain similar, you can port.
Okay. Okay. So what is supplement J then versus AC-21?
I mean, so again, I don't want to take up questions which are very specific case scenarios, because I don't want you guys to rely upon. I don't think we actually had this disclaimer. So did not give one. And Stephanie, if it's okay, I can just put it out there. So I
Yes,
don't want this to
absolutely.
be a session of legal advice. I mean, I don't want you. This is not legal advice. Okay. So there are, please don't hold me accountable for it. It's only a
No,
purely
no.
informational session. So
Yes.
I don't want people to take critical life decisions based on this stuff. But I mean, a supplement J is a requirement that we use to show a job offer, and we use it as part of any adjustment filing. We To show what the job of it is in the same particular field. So again, it's not about a form, okay? So that's why, if you know, in the beginning, the way I said it, it's not about filling forms. There is a whole rationale behind including everything and why we do it. So
Okay. Okay. Yes. Awesome. Thank you so much, Shweta. This really helps a
you're
lot.
welcome. Yeah.
Thanks, Naveen. Tushar, did you have a question? Tushar, are you there? All right. I think he signed off. Kedar, did you have a question?
Yeah, thanks. So hi, IK team, and hi, Sweta. Thanks for arranging this. I have a quick question. It's very specific to my case, though. So I had a priority date with my previous employer, Microsoft, and I moved to Dropbox a couple of years back. And when they ported my I-140, USCIS somehow made a mistake, and they didn't portate the priority date. And at least the attorneys here are saying that it's a cosmetic issue and it shouldn't a bit impact my ability to file I-485 or change the job. And if I change to say another company, and I can still will be able to port my Microsoft priority date. So is that true? They have filed a ticket with USCIS, but I guess it's been 2 months and they haven't even replied yet. So.
So you mean to say you mean to say that I'm trying to get your question, that the new I-140, that second one that you got, it does not show the old priority date?
Yes, that's correct. So it has a mistake where it is showing the new like the date which the I-140 was filed. So the date was not ported.
I mean, and they didn't amend it at that time?
No, they have filed a ticket with USCIS to correct it. But they are saying it's a cosmetic error and shouldn't impact my I-140.
It shouldn't impact. No, I mean, it shouldn't. If I was to do it, I would still argue, that you are. It shouldn't impact it. At the time of the filing of the adjustment, I would still argue that your priority date is current because of all this, whatever.
I see. So it's a cosmetic error then, right? Like we should correct it, but
Yes, yeah.
Okay, thanks. That's all my question. Appreciate it.
Thanks, Kedar, for your question. Sandesh, did you have a question for Sweta?
Yes, hi. Hey, Stephanie. Hi, everyone. Thank you for conducting this session. I'm actually currently working with IK team. So I am on my STEM OPT right now. I had my 2 chances of H1. They didn't got pick up for this year and last year. So maybe probably next year is the last option that I have. So my question to Sweta is like, if the third time, if it doesn't get picked up, do you think that people do recommend that the first day CPT is an option? So do you think is that a viable thing, or should we just like maybe give up the chance of that?
Look, I mean, I don't. I'm not going to say it's recommended or not. What I'm saying is, this is how I would answer your question. A first day CPT option is built in the regulations. Okay. It's not something that the university, I mean, you can't pull it out of your hat, right? It has to be something that the law authorizes you to do. And it does. Now, that being said, the problem that most people have with these options is, I'm guessing all these universities here that they are offering it, they're simply offering it to big and by because they are exploiting the loophole in this H1B thing, right? They're exploiting the situation that people like you find themselves in.
Correct.
So it's not that they are offering a program which is designed for day one CPT. That's not what they're doing. They're creating a program to to make money on the plight of people like you. Okay, that's what they're doing. Now, that being said, my sort of I know there are many attorneys, they take a very sort of a high-handed approach and they don't like it and they don't advocate for it and they think it's all fraud and scam. I'm not going that far, and neither am I advocating them. My point is, if USCIS has
Shweta, I think
I
you're
think
getting cut off.
yeah, I think she got a call or something, maybe.
if you have to do this option, if you ultimately want to consider this option, make sure that the university that you're going with for is legit. It's approved by ICE. You can check on ICE's page that it is they kind of they recognize it. It's got all its validations. On your part as a student, do everything you can to keep your status valid. Attend all classes, do whatever coursework, grades, completion, whatever it is that you have to do to make sure that you are not jeopardizing your status in any way.
Yeah, that's what I actually thought, because uh, if we do our part correctly, I don't think that there is anything that to worry about, right?
I don't know about that. I can't answer for that. Like, if tomorrow ICE comes down on these universities and shuts them, they can. definitely. But at least till they are not, they are legit.
So like if tomorrow I shuts them down and I get out of the university, will I get a mark on my visa the next time I apply in H1 or something? That
It's not a very simple answer. I mean, to that question, I mean, this stuff happened couple of years ago with what was that university, Tri Valley. They got into a lot of shit trouble, and students. So some students did not get impacted by it at all, in the sense that they didn't. Some students were issued a notice to appear before a judge. So if ever something like this does happen, there is a way around it. Contact an immigration attorney at that time to make sure that it doesn't come back and bite you later down the road. Okay, so but till then they're out. I mean, they are really enriching themselves at your expense. So
correct. So like apart from this, do you have any other option if we can go for, like, apart from going for this CPT? Is there anything that we could go for? Like, do you suggest?
no, not really. I mean, that's how most people are able to kind of keep themselves, unless you want to go and study further, or get a build higher. But otherwise, or any of the options we talked about earlier, working at an overseas office of some of these
Yeah.
companies.
Yeah. Okay. Sure. Yeah. All right. Thanks, Sweta. Thanks, Stephanie.
Awesome. Thanks, Sandesh, for your question. So before we move forward with the upcoming two questions that are here with us on Clubhouse, we do have an interesting question that's come on our YouTube stream, Sweta. So this question comes from Murali, and his question is: can someone with an L1A visa, a 140 approved and an I-485 application pending, be able to switch the employer?
Yes, you can. So the portability that I was talking about in terms of the AC21 portability, it is even allowed for L1s. It's a bit more tricky, but because you do have to switch to a similar position, and that's where similar becomes more challenging, because L1s are about managerial and executive positions, right? So, for instance, if you are in your current job, you are managing a team of 10 people and you are in a tech company, you can totally move to, say, a fintech or some other company, as long as you continue to manage the same number of people or the same. But if you're managing 10 and suddenly you're managing hundreds or thousands, or vice versa, then it's not a similar position. Why? Because here similarity is evaluated based on your executive and managerial role, not on the core, not on the nature of the company's business. So one company could be a toy company and the other company could be a tech company. It doesn't matter. What matters is how many how many people are you, what kind of teams are you managing, whether it's an executive, whether it's functional manager, executive, or um, or a purely managerial position. But so just short answer, yes, you can, provided both the nature of both positions is similar.
Awesome. Thanks for answering that, Shweta. All right, Harikant, did you have a question?
Yeah, hey, thanks, Stephanie. Hey, Sweta. I have a quick question. I'm on H1B, and in January 2020, my company filed for the extension, and I got approved 797 till August 2022. And at the same time, I was trying for other job, and company B also filed for 797 my H1 transfer and for my dependents. But I didn't take that offer, and we didn't go for the biometrics for my dependents. And recently I got a letter from the USA saying that case it got denied. So my question is that a red flag or something I need to do from my end, or can I ignore it?
I don't know whether, I don't think I'll be able to comment more without knowing more specifics. You mean to say the second H4 got denied and you didn't move to that job, right?
Yes, they
It
quoted the
shouldn't really,
reason.
yeah. So you didn't take up the H1 transfer or whatever, and that's why you didn't go for the H4 biometrics for that one. Is that
Yes.
how I I don't think it should really matter, honestly, because as long as your dependent's underlying H4 status is valid, you should be good. But I don't think it should really matter. From these facts, I don't think it should matter.
Okay. Yeah, they clearly quoted that the reason also you didn't attend the biometric appointment, and that is why they are denying that.
No, should be okay.
Okay. Thank you.
Thanks, Harikant, for your question. Pradeep, did you have a question?
Yes, yeah, thanks Rashmi, for giving me the opportunity. So, yeah, my question is specific to my case. So I have priority date of June 2013 in EB2 category, but my current employer is yet to begin the immigrant application process. So I'm unsure about the timelines of getting the perm and I-140 approved. So my question is, if I decide to move before, before anything is done on the perm side, right, with my current employer, will there be a problem with my future employer in the sense that, I have a date, but with my current employer, I'm not interested in doing any immigrant application process. Now, if I decide to switch to a new employer, will there be a problem in terms
No,
of
I mean,
getting?
if you're not going to be working for them, then I don't see why they have to do one. It's not that every employer that you work with has to do an I-140 for you, right?
Right.
That's not the thing. Is whenever your final action date is current, at that time, either that employer should have an offer, like a perm or an I-140, or you should have quoted under the AC-21 sort of provision. But there is no requirement that this all intermediary employers have to have a perm or an I-140 for you.
Okay, I see. Sure. So, yeah, just a follow up on that. So, my 140 is still not revoked with my previous employer. So, does that make any difference in terms of getting my future, perm or 140 approved with a different employer, or it doesn't make any difference?
No. I mean, your new employer, whichever you will go, they will do the perm and the I-140 again, and they will keep that old priority date for you. I mean, they will recapture that date for you. So I think that should be fine.
Fine. Okay, sure. And just a last question. So, I have, my first 140 in EB2 category. So now people are looking for, filing the immigrant application in EB3 category. Do you think that's a right switch to do? When it's a right switch because
I
of
mean,
the
if
dates,
the
right?
EB3 is
Yeah.
right, is the EB3 current right now? That is because of that?
Yeah, it looks. I mean, yeah, it's current
No.
compared to
So
EB2.
the only
Yeah.
thing is that remember, your H1 cannot be extended. Like you so far you get an H1 extended based on the approved I-140, right? But
Right.
if once the final action date becomes current, your H1 cannot be extended. So let's say at this point, if you are doing under an EB2 and your final action date is current, then how would you get your H1 transferred to this new employer? So you have to use an EB3. I mean, basically make sure that you use the I-140 that you are using to transfer your H1 to this new employer and get a 3-year extension. You cannot have a final action date which is current on it.
Okay. So okay, but the thing is, if my current employer is it's not willing, or I mean, I can push him to file the perm and everything, but it might take some time. Now the only question I have is if it becomes current, right? So I would miss the opportunity, right, of filing for adjustment of status.
Yes,
So
yes.
okay. And so even though if I miss the opportunity, right, but it should not jeopardize my portability, right? Will that be a problem? Like say, I don't want to go with this employer, but I switch jobs and find a new employer who can actually do the immigrant petition for me. So the portability still will be valid, right? Even
I
if
mean, I don't know which portability are you talking about. I mean,
the
there is an H1
AC21. Yeah,
The
H1 portability.
AC21 portability is coming because of, it's got nothing to do with the H1. The AC21 portability is coming from the fact that your I-485 is pending for more than 6 months, and you have an EAD. So that is the your current employer is not doing a 485. So again, I don't want to go into so many specifics because I don't think I get all the facts, and to I don't want you guys to take wrong decisions based on this. So if you really have something more deeper than this, do connect with me offline.
Okay, sure. Thanks, Sweta. Yeah, I think that's helpful. Yeah.
Thanks, Pradeep. Thanks for your question. So we've gone already 20 minutes over, so we will be just taking one more question. So Tushar, did you want to share your question with us?
Yes, thank you. Thank you, Stephanie and Sweta. Um, I have a question about the downgrade from EB2 to EB3. And my question is it advisable or is it advantageous or disadvantageous to apply for start the downgrade process by applying for I-140 before, let's say, October 2021, when these new numbers come up, rather than going for concurrent filing of I-140 and 485. So that's what I would like to know. For example, I mean, if
start filing when? I'm sorry, before October?
Yeah, before October. Let's say that in the October, the situation becomes such that it is it is advantageous to actually go for the downgrade from EB2 to EB3, and anticipating that such a thing would happen, that EB3 rates would move ahead much longer than in October 2021. So if I start the downgrade process right now in June, and if I get an approved I-140 EB3 I-140 before October 2021, will it be any advantages that because I would like to know that.
I don't understand what the thing has to do with the bulletin actually. I'm sorry.
Right. So I have an approved EB2 I-140, and there is a certain priority date. Assuming that in October visa bulletin, the EB2 date is not reached for filing for
I mean, my point is, if it's not current now, I mean, you only will don't do the downgrade on the assumption of what will happen in October.
Okay.
You can do it when you actually see the visa bulletin does. Hopefully, you will get some advance notice. It'll come out in the middle of the month, generally, not all the time. For the next, so it's not that it's you have some advance notice as to when to file. So I wouldn't downgrade in anticipation of anything. Who knows how things will go forward? If one particular month you see that this next month EB3 is current and you can downgrade, if based on your priority date, if you downgrade, it will become current. That's when you take the action. Why would you take it beforehand? That doesn't make sense to me.
Correct. My only idea was that if it is pre-approved, then maybe it will speed up the
No.
later.
It has nothing to do with that. No. I mean, that's just too much of a gamble to downgrade right now, thinking that something will happen.
Okay.
No. I barely will take any gambles on predicting it. To act upon it is just not needed.
Yeah, sure. That sounds good. Thank you so much. Yeah.
Thanks so much, Tushar. All right. Thanks everyone for joining us this evening, and especially thank you, Sweta, for coming in and answering all these amazing questions for us. For everyone that's in the audience, we do sessions like this just about every single week. We'll have another awesome session next week. So for you to stay up to date with the sessions that we're doing, click on our club at the top, Great Careers in Tech. If you want to learn more about Sweta, about her law firm, feel free to connect with her. Do follow, click her photo and follow her profile. Otherwise, thanks so much everyone for joining us, and hope we see you all again.
Thank you. Thank you, everyone. Yeah. Hopefully this was helpful, and you can reach out to us offline as well, and we'll be happy to assist you.
Thank you.
Thanks. Thank you, Sweta. Have a good night.
You too.
Bye.